Good morning, everyone. We can see a few people are still joining us as we're starting, but we thought we'd best get started now. I'm Rowena Rowley, Head of Provider Governance at the Office for Students, and I'm here to welcome you to today's Insight event. As regular attendees will know, we hold these events roughly twice a year, each time focusing on a specific topic. Our Insight events are intended to promote debate and discussion around particular issues and themes which are central to the Office for Students' strategic objectives and our regulatory role. They draw on the knowledge of industry and sector experts to inform providers, students, policymakers, and the wider public about some of these issues and to support our own policy development. Today's Insight event will look at some particular consumer protection issues. Please do note, however, that nothing we say today should be taken as legal advice in respect of consumer protection law. Thank you. Next slide, please. I'm going to start with some housekeeping points before we move on to the main session. Closed captions are available. Please click the CC icon if you'd like to see those. We are going to be posting a recording of this event on our website afterwards, including the slides. Please do use the Q&A box to ask a question. There's plenty of opportunity for engagement with our speakers and panelists today, so please use that option to get your questions through to them. And if you need to talk to the events team about logistical or practical issues, please use the chat box. Thank you. Next slide, please. We've got a really full agenda today, and we'll be starting with a welcome from Lord Wharton, our chair at the Office for Students. Our keynote address is going to be delivered by Susan Lapworth, Chief Executive at the OFS, followed by the opportunity for a Q&A with Susan. As I've mentioned, please do use the Q&A box to submit your questions. After the Q&A with Susan, we're going to be very pleased to be joined by Gordon Ashworth and Joe Nuckley from the CMA and OIA respectively, who will each be giving a presentation before we move on to a panel discussion with other key stakeholders in this policy area. And Susan will then be wrapping up the event with some closing remarks. In terms of timing, we're aiming to finish at 12:30 today, and we've allowed for nearly an hour for the panel discussion at the end. We've also built in a short 10-minute break halfway through the session, so we'll let you know when that's coming up. So please do send in any questions throughout the session to the Q&A box. Next slide, please. And with no further ado, I'm delighted to hand over to our chair, Lord Wharton, for an introductory welcome.
Thank you very much, Rowena, and welcome everybody. It's been a really well subscribed Insight event, which I think speaks to the importance of the issue at stake, the student as a consumer in an emergingly marketized higher education space, and how we protect the student and ensure that they get the value that they should rightly be able to expect and the experience that they should be able to expect from their time in higher education. It's particularly striking that there are a large range of different organisations who are taking part and who are watching this Insight event. We have lots of sector representatives and bodies. We have, of course, higher education bodies themselves, but also lawyers. We have journalists. This as an Insight event has sparked a lot of interest. I think that speaks to the importance of the topic and of the reality that it is an area that continues to emerge in the way that it's going to function. We will, of course, talk a little bit about the OFS and what we do, and Susan, our Chief Executive, will be up next to give a keynote on that and talk about our role in this space, the powers the OFS has, and the work that we do to protect students, which is, of course, key to our mission as a regulator, but it's also key to ensuring the long-term success and reputation of higher education in England. The emergence of the student consumer is connected, as I say, to that marketisation of higher education. This has been a series of reforms stretching now over decades. It's changed the shape of higher education and how it's delivered. And we need, all those of us who are stakeholders in higher education in England, to ensure that we adapt and evolve the way that we undertake our roles and perform our duties and understand the environment in which we are working and interested to create the best possible framework and environment for those who are reliant on it. In the course of the next few hours, we're going to hear from some of the organisations that are involved in that have responsibilities for parts of that. Particularly pleased, of course, to have the CMA, the Competition Markets Authority. Competition law is an important area. We're going to learn more about their role and their revised guidance for the HE sector and how to comply with some of the areas of consumer protection law that are relevant in this space. We've also got the Office for the Independent Adjudicator. They, of course, deal with the individual issues or complaints that may arise between a student and a provider. We will hear a bit about the trends in that, what's happening now, how it's changed and evolved, and what their role is. We organise these insight events to spark debate, to inform those who take part, and to help us all better understand the roles that we each as organisations and individuals have, and also the environment in which we are working. I'm, as I say, delighted to see such a good attendance for this Insight event, and we do publish alongside Insight events a briefing that goes with it, which is available on our website as Protecting Students as Consumers. So we will publish that. We will have a recording of this, as Rowena said, available for those who either aren't able to attend or want to review it afterwards, which we'll make available on our website. We have a wide range of different views represented here today. We're looking to be part of and spark that debate, and also to further inform and improve understanding right across all of those with an interest in the sector about how it works, how we can best protect consumers, and that is to say students as consumers, and how we can ensure that going forward things continue to make progress and get better. So with no further comments from me, I'm delighted to hand over to our Chief Executive, Susan Lapworth, who will now give the keynote opening address. Susan, over to you.
Thank you, James, and good morning, everybody, and thank you for finding the time to join us today. I suspect most of you will be familiar to some extent with the Office for Students, but for those of you who aren't, a few very quick words of introduction. The OFS is the statutory regulator for higher education in England, and we want every student to have a fulfilling experience of higher education that enriches their lives and careers. Our work has two main areas of focus. The first of these is quality and standards. We think all students should have a high quality academic experience which broadens their knowledge and skills and equips them for future work or further study. Our second area of focus is equality of opportunity. That's about ensuring that all students, regardless of their background, can benefit from higher education. And we think that those two things, quality and equality, go hand in hand. We're not doing our job if students disadvantaged by their background are recruited onto poor quality courses with disappointing outcomes. So where do the rights of students as consumers fit into that picture I've just given you? In his introductory remarks, James just talked about the idea that students are consumers. That's certainly still a contested way to think about the relationship between students and universities. It involves seeing students as customers who buy educational services from a service provider. And that feels very different to seeing students as members of a learning community and perhaps part of a common endeavour to generate, share and test new knowledge. But students can be and are both of those things. And it's in their interests that we don't overlook the former, their interests as consumers, by focusing solely on the latter. The importance of these issues has been underscored in recent times in England. We've seen students shouldering the majority of the financial burden of their higher education as a system of government-backed loans has replaced funding for institutions from general taxation. And that shift in funding arrangements has generated important questions from students, their parents, and from the wider public about what students are receiving for those fees, and the extent to which a course delivers what was promised and represents value for money. And of course, the pandemic and current industrial action in parts of the sector raise really challenging questions about how institutions should respond when they're not able to deliver courses as students had expected. So these are very real live issues that have the potential to affect real students in relation to the biggest investment that most of them will have made at this point in their lives. So thinking about the rights of students as consumers isn't a dry legal or regulatory matter, although it can involve grappling with some really technical issues and looking very carefully at the particular facts of individual cases. It's not an idea that undermines the very purpose of higher education. It's an important part of the infrastructure that protects students as they enter relationships with organisations that generally hold most of the power in that relationship. And it's perhaps worth saying here that at the OFS, we expect institutions to treat all students as consumers for the purposes of consumer protection law, whether or not they strictly fall within the legal concept of a consumer. You'll hear from other speakers this morning about some of the details of consumer protection law, and as James suggested, you'll find out more about that in the insight brief we published this morning. So I'm not going to rehearse those detailed technical points. Instead, I'm going to talk a bit about the OFS's particular role here. The OFS is one of several bodies with an interest in consumer protection in higher education, and I think that means that the landscape can sometimes feel complex. We'll hear later from Joe Nutley from the Office of the Independent Adjudicator. The OIA adjudicates complaints from individual students when they've not been able to resolve concerns with their university. It can make recommendations for redress, and it shares the learning from all of those complaints across the sector. So resolving individual disputes between students and institutions is the OIA's job, not the OFS's job. You'll also hear from Gordon Ashworth from the Competition and Markets Authority, and the CMA is the UK's lead competition and consumer authority. It has compliance and enforcement powers in relation to consumer protection law. And really importantly, in our context, the CMA has also published advice for higher education providers on consumer law, and that's been recently updated. And I expect Gordon will talk about that when he speaks. Also important are various trading standards bodies. So for instance, National Trading Standards works with local authority trading standards departments. And unlike the OFS, they have powers to enforce consumer protection law. I'm conscious I've been telling you what we don't do. We don't deal with individual student complaints. We don't have powers to enforce consumer protection law. So what is the OFS's role? Well, of course, we work closely with all of the bodies I've just mentioned, but our particular role is to set the norms for our sector, for universities and colleges. And we do that in two ways. First, we impose requirements for the quality and standards of higher education courses. And second, we regulate to incentivise compliance with consumer protection law across the sector. And I'll say a bit about each of those two things in turn. We've done a lot of work on quality and standards over recent years. We impose conditions of registration, we call those the B conditions, on all of the providers that we regulate. Amongst other things, they require every course to be up to date, to provide educational challenge, and to ensure students develop the skills they need for their careers. We require institutions to provide the resources and support students need to succeed on their course. And we expect assessment to be rigorous and for qualifications to meet the standards we set. So through our work on quality, we're defining what students can expect from their course. So what good enough looks like in terms of the educational service that they're buying from their university or college. We hear students' concerns about quality through our notifications process. Around 18% of the notifications that we've received have related to the quality or standards of courses. So for instance, students tell us about poor quality teaching or insufficient staff or limited resources or less opportunity than they had expected for practical learning. And in that context, it's helpful to remember that consumer law requires a university to provide educational services with reasonable care and skill. We think our requirements for quality and standards are likely to be relevant in judging whether a course has indeed been provided with reasonable care and skill. Although I should say that compliance with our conditions doesn't necessarily mean that a provider is complying with consumer law. So you can start to see the link between quality and standards and consumer law. So if I turn to that second point then, we see our role as setting sector norms in relation to expectations for consumer law itself. We've done less work on this than on quality, but there are some foundations in place that are helpful here. And you can see this in other of our conditions of registrations, the group we call the C conditions. So we require all providers to have due regard to the CMA's guidance as they develop their policies and procedures. That's a fairly softly framed regulatory requirement. We require them to cooperate with the OIA's student complaint scheme, making sure that students are aware of their ability to use that mechanism for redress. And we ensure that a provider has set out what it will do to protect the interests of students if a course or campus closes, or if the whole institution is no longer able to operate. And again, students tell us through our notifications process when they think they're not getting what was promised. Around 13% of the notifications we've received are on these sorts of topics. So for instance, students tell us about cancelled lectures and seminars. They tell us about course content that differs from that was advertised, and they tell us sometimes their complaints are ignored, and they can point us to contractual terms that they think are unfair. And you can see that all of those are relevant to judgments about compliance with consumer law, and they're perhaps signals telling us that not all institutions are getting this right for students. So what do we do with all of that regulatory intelligence? As I said earlier, we can't act on behalf of individual students or resolve disputes, and we don't have consumer law enforcement powers, but we can and do make judgments about whether a university or college is complying with consumer protection law for the purposes of our regulatory requirements. We routinely discuss concerns with institutions about compliance, and we might seek to encourage or incentivize compliance in various ways. And our general aim here is to ensure that a provider amends its policies or procedures or terms and conditions to comply with the law. As always, our approach depends on the particular circumstances of each case. So for example, if a university is closing a course or a campus, we may intervene to ensure that students are properly informed of changes within a reasonable time frame and are supported properly to understand their rights, including the right to complain and escalate concerns to the OIA. In other cases, universities have made changes to their terms and conditions and improved protections for students as a result of our intervention. And here we're likely to try to engage with the provider to achieve improvements without the need for more active regulation. But we can take more formal steps too. We could impose a targeted specific condition of registration to require a provider to comply with consumer law or with particular aspects of the law. And then we could take enforcement action of our own if there is a failure to comply with the requirements in that condition. Or we could decide to refer a case to a body that does have consumer law enforcement powers. We've recently developed a partnership with National Trading Standards, allowing us to refer potential breaches of consumer protection legislation to them. And the focus here includes unfair terms in student contracts that perhaps aren't clear, intelligible, and unambiguous, or terms that require students to pay charges that might be unfair, or that limit a provider's liability or allow it an unreasonably wide discretion to vary course content and structure. National Trading Standards can then use its enforcement powers on those issues where that's appropriate. We expect to be able to publish more information about the cases we've begun to refer to National Trading Standards in due course, because we think the issues that we're seeing in those cases are relevant to all institutions. And publication here is an important regulatory tool to help all providers understand how to comply and to encourage them to do that in practice. To conclude, I'll look just a little bit further ahead. There has clearly been progress across the sector since the CMA's first interventions on consumer law in higher education, getting on for a decade ago. But we think there is still much to do to improve understanding of consumer protection law and to ensure that students all benefit from those protections. As I said earlier, we routinely see cases that prompt concerns. And so we're now considering whether and how we might strengthen our regulatory requirements in this area. So what norms should the OFS, as the regulator for this particular sector, set for consumer protection? Should we define more fully the information we expect every institution to make available to students when they're making those high stakes choices about what and where to study? Should we look at the way other regulators, such as the Financial Conduct Authority and Ofgem, have sought to protect the interests of consumers, for example, by introducing a new general principle that requires providers to treat students fairly in all that they do? Is there a place for a model contract between universities and students to set out fair terms that all students can understand? And our complaints process is working as well as they should right the way across the sector. All of these are open questions. We want to explore them further with students and with the colleagues in student unions and institutions who have deep expertise in supporting students when things go wrong. And of course, we want dialogue with universities and colleges on these issues too. I expect we'll find that the interests of students and the interests of institutions may not be well aligned here. In the meantime, the publication of our insight brief today, following hot on the heels of the CMA's updated guidance, is a signal to the sector that these issues may need a fresh look. So we're inviting you to do that now to ensure that all students are being properly protected as they choose their course and while they study. Again, thank you very much for joining us this morning. I think we're going to do a Q&A session now, and Rowena has just appeared, so I must be right about that. So over to you, Rowena.
Thank you, Susan, for your introduction, and thank you very much to those of you in the audience who have sent in questions. We can see we've started to receive a good number of those. We've got about 10 to 15 minutes for this Q&A session with Susan, so we will try to get through as many of the questions as we possibly can in that time. So Susan, the first question for you is, why do you think this is an important issue for students?
I think I just touched on this a little towards the end. Students are making a really significant life choice about going to higher education in the first place, and then choosing the institution and the course they want to follow. And that choice now involves significant financial commitment. And I think we would all agree that in that relationship between an institution and a student, most of the power sits with the institution. So I think it matters very much that students have the right kind of information to help them make good choices, that the contractual arrangements are fair and reasonable, and that they are protected while they study and can raise issues if something goes wrong. So that seems quite fundamental to me, and I think we will hear some student voices later in the session, but that is what we hear from students who contact us.
Thank you. And so particularly thinking about kind of post-pandemic education, how does the move to blended learning, online and in person, affect students' consumer rights?
Well, I think we're talking about the same themes, aren't we? So it's really important, and the OFS has said this to institutions, that students are really clear how their course will be delivered when they're choosing it. So it's fine for a high quality course to be delivered wholly in face-to-face mode. It's equally fine, I think, for a high quality course to be delivered entirely online. And we have some excellent examples of both, but students need to be clear which it is, and often of course it's a mix of the two. And if an institution is delivering a course through blended means, then again students need to be clear what it is they can expect right the way through their course, so that they can make an informed choice about whether that's right for them.
Thank you, Susan. And what could you expand a bit on what the time frame is for the Office for Students in terms of looking into those issues, such as a model contract that you've just mentioned?
Yes, we started to do some work on this in December 2019, and then of course the world changed quite quickly as we got into 2022, and we were all of us focused on more immediate issues as the pandemic unfolded. So we want to pick up the thread of that work now. The pandemic was helpful in this respect because it focused attention on some of these key issues. So some learning from the past 2 or 3 years that's moved on our understanding of where we might best contribute to these issues. And we've said in our business plan for the current year that we will develop our thinking through this year, engaging, as I've just said, with students and those that support them, and with institutions, to think about what shape the next iteration of the OFS's work here should take. So a conversation and dialogue over the next few months, I think, is the next thing to look out for.
Thank you, Susan. And I can see there's some other questions just coming through. While we're just waiting for those to come through, is there anything additional you'd like to say about the relationship with the national trading standards that we've recently set up?
Yes, I thought that was interesting. I think it was. I talked earlier about a complex landscape in this area. So lots of bodies doing really important work on this range of issues, but perhaps quite tricky to understand who was responsible for which part of the jigsaw. So we've been working over time with that range of bodies to make sure that there is improved clarity about who does what, particularly for students. One of the things that we were conscious of very early on in the OFS's life was, as I said earlier, we don't have enforcement powers in relation to consumer law. That's not our job. And that raises questions about what it is we as the regulator should do when we see examples of practice in universities that perhaps aren't compliant with consumer law. And forming a relationship, as we've done with national trading standards now, with a body that does have those enforcement powers and has really deep expertise in these issues, felt like a helpful way for us to be able to take the issues that we were seeing and have them addressed meaningfully in the real world by an expert body. So that relationship is up and running, it's working well. As I've said, we've started to refer cases, and we will hope to report on how those cases progress and the outcomes of them in due course.
Great, thank you very much, Susan. I think we're going to draw that Q&A session to a close for now, and I think we're going to move on to introduce Gordon Ashworth. So Gordon, I don't know if you would like to join us on screen, and thank you very much, Susan, for that very interesting introduction. Hello, Gordon.
Hi.
So I'd like to introduce everyone to Gordon Ashworth. Gordon is the Director of Consumer Protection at the Competition and Markets Authority, which we know as the CMA. Today, he's going to be speaking about applying consumer law in higher education. And following his presentation, there'll be an opportunity to also ask Gordon some questions. So as previously, please do use the Q&A box to send those in. Thank you very much, Gordon. Over to you.
Okay, thank you very much. Well, hello, everyone. Good morning. I am Gordon Ashworth. I'm Director in the Consumer Protection Group at the CMA, the Competition and Markets Authority. Thanks very much for the invitation to come and speak here today. We did a lot of stakeholder engagement and conversations with people back in 2014, 15, 16, but less so in recent years. So it's really nice to be here. And as has already been mentioned, we've just published on the 31st of May an updated version of our 2015 guidance. So I'll be referring to that. Next slide, please. So a little bit about us for those of you who aren't familiar with us. We were formed in 2014. We were originally, some of us, in the Office of Fair Trading that predated the CMA, and the OFT merged with the Competition Commission for a wider set of reasons that I can't really go into here. But the CMA was created, and inevitably some bits of work straddled that transfer, and this is one of them. Are interested in higher education, but I'll say more about that in a second. We have a wide variety of functions, some of which are not discretionary, so there are things that we're obliged to do, and then there's other areas where we have a choice about which work we take on and when we do it. So our functions include, we've got on the slide there, mergers, competition law investigations, market studies, but we also, as I think you know, a consumer law enforcer. We do work in price fixing cartels. We've got some post-Brexit responsibilities where we run what's called the Office of the Internal Market, and also a subsidy advice unit to pick up things that needed to be done after we left the EU. So a broad range of responsibilities with no specific remit in higher education. So we're not a sector regulator in any sense like that for HE, but we do have, as highlighted on the slide, some broader functions about providing information and advice about obligations and rights under competition and consumer law. And also we're a consumer law enforcer, so we can take cases under consumer law. Just highlighting that first bullet, we don't provide individual advice about individual circumstances. That was an OFT role to some degree, but that's been passed out to citizens' advice, and I'll mention a bit more about that later on. Next slide, please. So the background to our interest here, as I said, it goes back to the Office of Fair Trading, and in March 2014, just at the end of the OFT, we published our findings on our call for information into the undergrad sector in England, and it recommended in the transfer of power that the CMA clarify higher education providers' obligations under consumer law. So we embarked on quite a wide period of stakeholder engagement. We carried out a public consultation, and we published our advice in March 2015. And our interest in the undergraduate sector particularly related quite clearly to the 2012 increase in fees to £9,000 and the impact that has on consumers, and the importance of impact on students, and the importance of consumer rights that went along with that change. And as Susan's already said, it's a shift that was happening over a longer period of time. Following publication of the advice, we then let everyone have a look at it and consider what they wanted to do and make changes where necessary. And we came back the following year, having carried out a compliance review and published our findings there, which were very encouraging, I would say, at the time. We highlighted some things that still needed to be improved, but we thought generally people had taken notice and made improvements, and that was good. And then we also took some enforcement cases, which you might be familiar with. They're can be found on gov.uk, and we dealt with a number of different issues. So terms dealing with course changes, increases to fees, additional course costs, and complaint handling, as well as in a number of cases academic sanctions that were being used for non-tuition fee debt. So a spread of cases there across a number of things. We haven't taken a case now since 2017, but we did a lot of activity around that period. Next slide, please. So our most recent activity, which you might be familiar with, is that when obviously COVID hit and the impact was huge on universities and on students, some questions started to be raised about where consumer law applied. We, in fact, felt that a lot of what we'd said originally back in 2015 and then in our compliance review in 2016 did cover the scenarios that people were talking about, although not specifically mentioning COVID, obviously. But on the legal principles, we thought we covered most of it. But because people were asking, we made a couple of restatements in November 2020 and then again in 2021. And we talked about admission offers and the provision of information to prospective students about potential changes to the courses they may be considering applying for, because obviously that was a big thing that was happening at the time in terms of changes that might be made and might need to be made at quite short notice. And then terms which could allow providers to withdraw or cancel an offer after a student had accepted it, and then terms which limited or excluded liability if providers sought to withdraw or cancel an offer. And then terms allowing providers a wide discretion to vary aspects of the agreed educational service, and terms which excluded or limited liability for a failure to deliver the agreed service or for delivering a different educational service. And I think it's fair to say that variation, limitation of liability, those are themes that come up on a fairly regular basis, and but they are addressed in our guidance. But we know people have interest and issues about how that can work. Next slide, please. So we've issued an update to our guidance on the 31st of May. Why now, you might ask? Well, I think we probably could have done it at other times in the last few years, but as I said, we're not a specific enforcer or regulator for the HE sector particularly, so everything we do has to compete with the range of responsibilities I talked about a couple of minutes ago. So it's a prioritisation decision essentially in terms of when we get involved in higher education work and resourcing, I'm afraid to say. So it's a combination of those two, but we did seem to have come to an important point, we felt, because when we published the advice originally, we just narrowly missed the coming into effect of the Consumer Rights Act. So ideally we would have had that in the original advice, but we didn't. Substantively on the law, we felt it made a little difference really, but the timing wasn't quite right there. And also the stakeholder regulatory landscapes changed. OFS wasn't around then, so some of those references clearly needed updating. We'd obviously also done the compliance review that I referred to, those restatements of the law from 2020 and 2021. So thought we'd be good to put all those in one place so people didn't need to refer across to various different publications. And although it's not HE specific, we do have, because we're the unfair terms policy lead as designated by government, we produce the CMA's general unfair terms guidance. So we've incorporated that as well. So a lot of what you'll see in it is very familiar. The structure's very familiar, the same really, but there are references and updates that you'll find relevant and important. So we do encourage everyone to have a look at it. Next slide, please. So just briefly on the legislation that we cover, and you may well be familiar with a lot of this. The Consumer Protection from Unfair Trading Regulations. This deals with unfair commercial practices, particularly misleading actions, including misleading information, misleading emissions, aggressive practices. And then the Consumer Contracts Regulations from 2013, which require certain relevant pre-contract information to be provided before students accept an offer. So two pieces of legislation that deal with information provision, which is not ideal, and there is some overlap as we talk about in the guidance. So you kind of have to work your way through that. The concept of material information, which is really important, comes out of the CPRs, pre-contract information out of the CCRs. So those two really do have to be looked at together. And then the Consumer Rights Act, which replaces the unfair terms in consumer contract regulations. And in part 2 is where you'll find the unfair terms material and the fairness test that's applied to consumer contracts and notices. And important to stress, as I do quite regularly, only a court can decide if there's been a breach of consumer law. So clearly when we put out advice or guidance, we're giving our view of the law, which we're entitled to do as an enforcer. People don't always agree with that. So clearly when we go into potential court action or negotiating undertakings, other people can take a different view. Ultimately, although we always try and negotiate a settlement where we can in terms of what we consider to be breaches of the law, only a court can decide that. So that's ultimately where these things will be decided, although that didn't need to happen. Obviously, in the cases we took around 2016-17, we might still be talking about some of those cases, in fact, because the court process is not quick, I have to say. Next slide, please. So we continue to focus on undergraduates. That's not to say we don't occasionally get queries about postgraduates, but the focus of the original advice was on undergrads, and that's what we stayed with. Postgrads can be consumers as well, but that will depend on the particular circumstances, and there's plenty to deal with in the undergraduate sector. So that's where the demand was really. So that's what we did at the time, and that's what we've stuck with. In terms of trying to structure the guidance and try and make it as helpful as possible, and you'll notice I'm flipping between advice and guidance here. They're kind of interchangeable. There's a sort of technical reason why something might be advice rather than guidance, but it's just a terminology point. Most people would probably think of it as guidance. But when we structure advice like this, and we do it in quite a lot of sectors, so in recent years, things like care homes and IVF, various other areas, we try and think of the consumer journey or the student journey in this case, and we try and think through the process that they're going through. So we start off here with information provision, giving prospective and current students clear, accurate, timely information about what they need to make an informed decision, and then once they're in a contract, about whether those terms are fair and balanced between providers and students. And then in the unfortunate scenario where things can go wrong, as they sometimes do inevitably, ensuring that the complaint handling processes are accessible, clear and fair. So there's different ways you can approach consumer law in the sector and set things out. That's the way we chose to do it, and generally no one suggested particularly that's not a good way to do it, so we've stuck with that this time round. Next slide, please. So how does the law apply? Well, it's not a devolved matter, so consumer law is UK wide, and this is fairly well rehearsed territory now, but consumer law applies to the relationship between providers and students, as the provider will be a trader or seller for the purposes of consumer law, and that's even if they operate on a non-profit or charitable basis. And a student will be a consumer for the purposes of consumer law if they're acting for purposes wholly or mainly outside their trade, business or profession. And we believe students are likely still to be consumers even when they're studying a particular subject that may lead to a particular career, because there's certainly other career paths they could take. It doesn't inevitably mean they're going to go down that route. So that's the view that we've taken. And just to pick up what I was saying earlier about the fee increase back in 2012 and the things that Susan talked about in terms of the way this has developed over the years, in addition to the sort of legal technical definition of why students can be consumers, there are also more general characteristics that we see in terms of our other work. So the amount of time and money now that students invest in getting education and getting a degree mean that these things are really important to them, and it's a lot of money for something that you might not be happy with at the end, and you want to make sure that you're making that right choice at the start. And a lot of CMA's work is about ensuring that people are able to make informed choices about what they do and where they spend their money. And then there's that sense of you're in a 3 or more than that year deal, really, and so you're going to feel to a degree locked into that. Now you might be able to change, but it's difficult if you're unhappy or dissatisfied. It's not easy to walk away or start again, and because of that, ideally you want to get things right at the start. So that's why the information provision is so important, particularly as you enter into the contract and get towards enrolment. It's vital that you've understood that you've got the right course and you've made the right decision. So the minimum standards are what I've referred to there. So consumer law is the minimum standards that apply to various aspects of providers dealing with students. There will be other things clearly beyond that they do. It's kind of a baseline, really. So many providers are going well beyond that and doing other things, but this is, from a legal point of view, the base that we start from. And obviously consumer law isn't the only thing, has already been mentioned. There's other requirements on providers and there's other guidelines from sector regulators. So it's part of that that general suite of tools and functions that exist across the sector, of which we're just one of the people with an interest. Next slide, please. Information provision. So just a couple of things to say about this, really. Consumer law applies to all information provided in writing, verbally or visually. I'm sure you know that. Now, it must be clear, accurate, easily accessible, and not misleading. And we've approached information provision in 3 distinct areas: the research and application stage, so the potential students going out and looking for where they want to go, what type of course, where they want to be, what information are they picking up at that stage. Then more specifically, when they get down to actually having an offer that they can accept, and then on the enrolment stage. So again, we're trying to work that out through a sort of a logical progression in terms of how they're going through the process. And I've mentioned already, there's these 2 sort of parallel concepts of material information under the CPRs and pre-contract information under the CCRs, and there is some overlap there. So ideally, we would have merged that in some way, but clearly that's not the case. It's two bits of law, so they have to be explained separately. But hopefully, when you go through the guidance, you can see how they link up. And material information, the CPRs, is particularly the information that you need to be able to make an informed decision. Next slide, please. So once an offer is accepted, a contract for admission will be formed, and although there may be conditions to follow, you need to get the grades, but the contract is there. And the material information, with 3 bullets here, could have put 10 really, and if you look in the guidance, that there are plenty more. But course content and structure, how it will be delivered. So how it will be delivered is obviously particularly important. It's become more important in the last few years. Where does that balance lie between how the course, what face-to-face time you're getting, how much is online? So we would expect that is going to be set out clearly for potential students, so they can understand how that course is going to work. And then total course costs, tuition fees, and any extra costs, which was something we picked up on a lot back in 2015, the extra things that students might have to pay for: field trips, lab equipment. I'm sure there are several others, things that they may not have been necessarily made aware of at the time, but will be a cost for them later on, and on a tight budget, that's really important. They know about that and think about how that's going to work. So we're really keen to see that people make sure that those are included. And then if you fail to provide material information to allow someone to make an informed decision at all, or at the wrong time, or you give it a false impression, that you could be making a misleading omission or misleading action under the CPRs. Next slide, please. So we could say a lot here, but just some examples of misleading omissions and misleading actions. So, for example, a provider fails to provide information about total tuition fees and any additional course costs up front, as I just mentioned, in a timely way or at all. Failing to make prospective students aware of the earliest opportunity of changes to any of the material information provided. So earliest opportunity isn't defined, but for example, if you had a specialist tutor on a particular course, and that was a real important point for the quality of the course and also for the prospective students, as soon as you know, if it was to happen, that that tutor would be unavailable or left a very short notice, you should be making sure that the students are made aware of that as well, and what provision you're making to address that. Misleading actions: a provider, for example, presents information that suggests a course is accredited when it isn't, very important, and potentially where you give a misleading impression about the number of optional modules that will be available. Modules has been a topic that's cropped up many times before. That balance between core and optional modules, and what happens if you change optional modules, how they're classified. In one of our cases from a few years ago, dealt with some issues on that. Next slide, please. So terms and conditions. So essentially, the point here is that students should be able to foresee and evaluate the future consequences of entering into a contract. So the CRA, the unfair terms provisions of the CRA, are saying that a term will be unfair if it creates a significant imbalance between the parties' rights and obligations under the contract to the detriment of the consumer, i.e. student, and is contrary to the requirement of good faith. A lot bundled up in that, so that is the legal technical thing here. But essentially, some of the points I've made here are the most relevant ones on the slide. So terms and notices under the CRA must be fair and transparent, and we're talking about everything. So it's all contracts, rules and regulations, anything which you might be bound by, which together collectively form the contract. So that can be a lot of material, and clearly it's in everyone's interest, I think, that is organised and presented as coherently as possible, so that you're not getting into sort of discussions about what actually does the contract consist of, because there may be various elements to it. Terms must be easily located and accessible and written in plain and intelligible language. I guess common sense, really, in terms of easily located and accessible. You wouldn't want to hide them, you wouldn't want to bury them, you wouldn't want students to have to go and spend a lot of time trying to find them. They should be able to understand the terms, how they affect their rights, and how the terms could impact on them. So they need to be able to read the terms, look at their own personal situation, say what might that mean for me if something happened on my course. And as I've already said, in terms of what the CRA is fundamentally after, it's trying to get this fair balance between the rights and obligations of the higher education provider and student. If terms are found to be unfair, they cannot be enforced. Next slide, please. So a little bit more about easily located and accessible, and what isn't potentially great in this space. I highlight this because it's something that it did come up around 2014-15, and we looked at when we were reviewing some websites and doing some of our compliance work. Terms referred to in an offer letter or deemed to be accepted when a student accepts an offer, but the terms are in different documents in different places on the website. So the point I was just making a second ago, making them difficult to find and review. So that isn't ideal. Lengthy documents used to set out terms that apply to students. Well, it depends how you've presented your contract and your documentation, but you wouldn't expect students to have to seek legal advice to actually understand the basis of their contract. So to keep them simple and clear as much as possible, and that applies to the language that they're written in, ensuring it isn't difficult to understand. Don't use jargon, don't use unfamiliar expressions, and poor practice again would be to only provide those T's and C's at the time of enrolment, or only make them available somewhere which can be accessed by current students and not prospective students. So, for example, on a student intranet. So all of those things we would have classified as poor practice. Next slide, please. So examples of terms that could be challenged as unfair. So back to something I think I probably flagged earlier on. Terms allowing a higher education provider an unreasonably wide discretion to vary course content and structure. So for example, if a term was to say the provider may alter the timetable, location, campus, amount of contact time, how the course is delivered, etc., in very broad terms, and isn't it's given them plenty of discretion, isn't really giving the student much sense of how this is actually going to play. That's too much. That's too broad and going to be open to challenge. Terms that seek to limit liability, failure to comply with contractual obligations, in particular where providers provide something different to those contractual obligations, or in cases of non-performance or substandard performance. So, for example, a term which says if a provider fails or isn't able to provide the educational service and it's a result of its own default, and the liability of the university shall not exceed the amount of 1 year's course fees, that wouldn't be acceptable to limit it in that way. And then finally, academic sanctions. Using those in a blanket and disproportionate fashion for non-payment of non-tuition fee debt. So we've been over this territory quite a lot, and it was subject to a number of the cases that we took at the time. But it is disproportionate to be saying that a student can't graduate or progress to the next year if they've not paid library fees. There's other ways to approach those issues to head that nightmare scenario off, where that's what you're left with in terms of threatening them. There's other ways to approach that. So we were pleased to see the improvements that were made there when we took those cases, and others have told us that acceptance that isn't an appropriate way to handle things. Next slide, please. And I'm probably getting short of time, but I'll wait for the 2-minute warning. So complaint handling. Complaint handling processes, the sort of final part of the trilogy. They must be transparent and they must be easily accessible. And you must have information about the complaints process before you accept the offer of a course. Again, common theme, all those details must be easily located and accessible, whether it's on the website or an intranet. And you must get clear and accurate information about the complaint handling procedures, including who deals with it if you're working with someone else. So there's another party involved, whether it's OIA, SPSO, and IPSO, to be clear how that process will work as well. And if there is another body involved and they've got guidelines, for example, OIA's good practice framework, then if you're complying with those or following those guidelines, it's much more likely that your process itself will be compliant with consumer law as well. So ensuring it's all joined up and it's all compliant all the way through is really important. But just to say, it's not enough that the processes are transparent and easily accessible. At the end of the day, they still have to be fair. So you need to be able to set out a process which provides reasonable timescales. There shouldn't be barriers to students going through the process. They must be able to escalate complaints. So at the end of the day, there's always going to be the fairness test. It's not enough just that you've got a process and it's transparent. You need to ensure that it's fair as well. Next slide, please. So in the unfortunate situation, if students are unhappy with the educational service, and this, I think from the knowledge of a lot of people here, will seem a little bit undercooked in terms of there's lots of things going on here, which I'm not attempting to go into in any detail because we don't have a specialism in the CMA. But really, if you're looking for advice, you can obviously go through student offices, you go to your student union. I would also flag Citizens Advice Bureau for face-to-face advice or legal advice if you feel you have to. And there are in 3 instances I've set there. There's helplines, Citizens Advice, Advice Direct Scotland, and Consumer Line in Northern Ireland, all of which can give advice on consumer law rights. Now, I'm not going to pretend that they're specialists in higher education, but they do know consumer law. And when the government made the changes 10 years ago or so, Citizens Advice was given responsibility for providing advice on consumer law. So they are trained up to do that. It may not give you all the answers as a student, but it is, as we were saying, with any sector that we work in, it is the place to go. It may just be a first port of call. It may just be where you get some of the basics, but they can provide you with that information. And then, of course, you can go to third-party redress schemes and other regulators. You can take private action if you want to go down that route for CPRs or breach of contract. So those are the other options available. Next slide, please. So regulatory action that providers may face. Well, the second and third bullets talk about sector regulators and the QAA. I would just flag the Advertising Standards Authority because they're in a similar position really to the CMA to the extent that they've got a cross economy remit and no specific requirements on them to do work here. But their codes cover advertising and marketing communications, and they are likely to include course information, prospectus, leaflets and posters directed at prospective students. So there is a potential role for them as well. But then, yes, sector regulators, the QAA that I mentioned there, but I won't go into detail on those. And final slide, I think. Thank you. So, who might take action? So, we might. So, we're obviously Competition and Markets Authority with consumer enforcement powers. We're one of a number of what are called Part 8 enforcers under Part 8 of the Enterprise Act, who can take action under different aspects of consumer law. So, Part 8 is effectively an umbrella piece of legislation. There's lots of hundreds plus of bits of legislation listed under there, and Part 8 is the mechanism that allows you to take action. And we share those powers with a number of other enforcers and sector regulators in other parts of the economy, and with all local authority trading standard services or the Department of Enterprise in Northern Ireland. We can all enforce consumer law. Just to sort of recap on our role, we don't have a specific role here. Our work now, or work in higher education, is always subject to prioritisation and is in effect competing with other work for us across the office. We've got a very clear steer from government about how we apply consumer law. We're there to look for problems across markets, systemic problems. And although you'll see us taking individual cases, we're not taking individual cases for the sake of taking a case. So a trader does something wrong, we don't automatically do that. We would see that as something for trading standards to do. We would call ourselves, I would call ourselves not a day-to-day enforcer of consumer law in that sense. We're looking for that market-wide angle. If we take something, is it going to be novel? Is it going to set a precedent? Is it something that's going to have an impact on the market as a whole? That's not to say there are businesses around obviously that are doing things wrong on an individual basis, but we're looking for something which will have that wider impact. And I think that's why it's so helpful what Susan was talking about before with the role of national trading standards, because they are in effect day-to-day enforcers of consumer law, and the arrangement, as I understand it, that's been developed there is one particular authority developing a specialism, and they would take the cases or do the work. And we know the authority in question, they've got a lot of experience in this area, so that's a really good move. It's not asking or expecting the 200 local authorities around the country to all step up and do things at the same time, although we have worked once or twice with local authorities who are very keen to do work in this area, but it was quite difficult for them because they are very under-resourced and often lack the right sort of legal advice. But if you've got a specialist element of national trading standards who are a special team doing this sort of work, and they do this in various different sectors, then that's a good way forward. And that, I would on the face of it say, complements very well our market-wide role. And then just at the end, there are, under the Enterprise Act, enhanced consumer measures which are available to us and all Part 8 enforcers. So beyond just asking a business to actually comply with the law in the future and provide us with undertakings, there are more things we can do from changes made a few years ago. So we can seek financial redress. We can require a business, for example, to appoint a compliance officer, provide better staff training, put in a more robust complaint handling scheme, sign up to an ADR scheme. So those are all elements of ECNs, as we call them, which are important. I'm talking generally about businesses there because I wasn't thinking necessarily specifically about this sector, but I think it's just interesting to know that that is part of the toolkit that exists for us for trading standards and the other sector regulators that we work with. I think that's about it. I hope I'm okay on time.
Thank you, Gordon, for that incredibly interesting and informative presentation. I can see I'm not the only person that thinks that, because we're getting plenty of questions in for you now. We've got about 10 minutes for the Q&A session before we go to a short break, and we'll try and get through as many questions as possible. Obviously, we won't be able to answer all of them, but hopefully this will give us indication of the flavour of things that people are interested in. So the first question that's come through is, does the CMA intend to update the 2015 guidance for students?
So that's kind of what we've, oh, sorry, yes, the student guide. So there were two we produced back in 2015, the provider guidance and a shorter version of the provider guidance, which is kind of like a page, and we haven't touched that one yet. And then alongside that, there was a consumer piece as well. What we found when we were speaking to people late last year, and we talked to the NUS and others, was that we found people were going to the main provider guidance for what they wanted to know. So we didn't pick up that much use we made of the student guidance particularly. So we focused our attention on doing the main guidance. Now, if there was demand for that, we'd be happy to consider that. Again, it's subject to prioritisation, and we'd have to think about that across the piece with other work. But the feedback we got was, although it's designed for providers, that's what everybody seems to be looking at, and that's the one that people have been using. So we put all our attention into that. But point noted, and if people would find that particularly helpful, then we could give that further consideration.
Thank you, Gordon. That's helpful. So the next question is, how do we balance the need to give clear and accurate information up front with maintaining a cutting-edge curriculum, as well as being responsive to feedback on an ongoing basis on modules and courses?
So I think this is something I've touched on in the sense it's a popular topic, really. So what we're, as a competition authority, if we were seen as sort of trying to stifle innovation in some way, or development of things which are beneficial to consumers, that wouldn't be looked on particularly favourably. But really, what we're trying to say here, I think, is if you can front end as much of this as possible, if things will crop up, things will happen, you will get feedback about a particular course, you will want to make changes. But if you've made it as clear as possible up front at the start, these are the circumstances where we might need to make changes. This is how we'd go about it. We'd keep people informed. We'd let them know as soon as possible. We might take feedback on what we're proposing to do. We're certainly not trying to say that you can't do that. It is a difficult balance, and we try and talk through that in the guidance. But I think when you look at the cases we took, we weren't particularly trying to stifle anyone doing things that are important. And we've, I can't speak for OFS because obviously OFS sees information that we don't. But we're not trying to put people in a position where they can't do things that are right and beneficial to students. We don't want people to trip up on the law just for the sake of something. We're looking for things which are substantive, and also where people have made no attempt to address this at all, or very little attempt, and consumers are completely taken by surprise. So yeah, I absolutely understand the challenge, but we try and work through that in the guidance.
Thank you very much. So the next question is about student loan funding. It's quite a long question, so I can repeat it if needs be. The question is, while students are making a significant commitment, many do not pay for their studies, but take a loan from the student's loan company, which is then not repaid until after they've left university or college and their earnings exceed the threshold. If students claim a refund, for example, on account of changes to services due to industrial action, to whom should that refund be paid if the institution agrees to make a payment? Question, is it back to the SLC? And the further question is, if it goes to the SLC, will that benefit the student given the way the student loans are repaid?
I will be absolutely upfront and say I don't know the answer to that one. That's not something that we've thought through particularly. I'm happy to take that one away, and we can give some more thought to that one. And apologies to whoever asked it, because it's quite a long. Thank you for taking the time to write a long question. But I haven't thought that one through particularly. Sorry about that.
That's no problem at all. Let's move on to the next one. And this is about accommodation. We are getting a few questions about accommodation. And the specific question is, where accommodation is not owned by a university, but they're advertising accommodation on behalf of a landlord under a nomination agreement or a license, does consumer law apply to the advertisement by the university?
If you're using that as a selling point, so accommodation, as we mentioned, I think briefly in the guidance, is something that's really, really important and increasingly important because of the shortage of it. And also, we did see lots of accommodation questions in COVID as well. But if things are presented to the student as being important, as being a selling point, something they can rely on, it's not sufficient for the provider to say, well, that's actually a third party or nothing to do with us. If it's part of the advertising materials that are presented to the student, even if it's coming from somewhere else, then you have to check that's right. I know that's not always straightforward, and it may not be obviously your accommodation as the question says, but you do have to do what you can to ensure that those the information you're providing is correct. You shouldn't just take that at face value. You should make inquiries and give the appropriate level of detail so students can make an informed choice.
Thank you. And then I've got two practical questions. And again, you might want to take these away, Gordon, but I'll read them out and you can let me know. The first one is, it's not easy to tell what has changed between the 2016 and 2023 guidance. Would it be possible for the CMA to highlight the relevant text? That would be very helpful.
So I think if you go on Gov UK, you can still find the original one, which is now, we don't think we've taken it down. I think it's still there. And the reason we've taken it, it's still there, is because anyone who was looking at it previously, we didn't want to remove it if it's already relevant to something that might be happening or a case that they might be involved with. We'll see what we can do with that. We're saying substantively it's the same, but clearly there are references here and there. And I know we've made a lot more use of footnotes, which will thrill the lawyers, but not everybody else, in terms of relevant cases. And there is other new case law mentioned. But if there's anything we can do, whether we could kind of flag that in some way, don't know if we could mark it all up, but if there's anything we can do, we'll give that some thought. Thank you.
Thank you. And this is another kind of practical question. We've had which is about the accessibility of terms and conditions, presumably of the universities and colleges. CMA recommend that terms should be provided in a PDF format, but that's not good practice on accessibility for students with visual impairments. Okay. And the person asking the question says, do you have any recommendations on how to manage this?
Fair point, absolutely, and we'll take that one away. Yeah, I haven't got an answer to that, but good point, and thank you for raising it.
Thank you very much, Gordon. And so the last question before we move to our break, it's another accommodation-based one. And the question is, some students do not clear their accommodation debt, which can amount to several thousand pounds plus before graduation. Universities often do not have forwarding addresses after students graduate. As universities cannot withhold graduation before students clear their accommodation debt, what are the other revenues that you're alluding to that is available to universities to recover such debts?
So I wasn't necessarily alluding to revenues, more other routes that don't allow situations to develop. So it's probably not what the question is thinking of, but I was thinking of other ways in which you can ensure that a debt doesn't get to the actual state that it does. I mean, we talk about use of debt collectors in appropriate debt collectors in the advice. I mean, it is a very difficult situation. I absolutely appreciate if you're at Last Chance Saloon, you've tried everything, and then you're left with a huge accommodation debt that you can't track down. But I think also we're probably going back here to sort of practical steps that can be taken. Academic sanctions we don't approve of, but if there's other ways that debt can be recovered, if they're flagged up at the start, and as long as they're fair in terms of terms and conditions, then that's something that can be considered. But that problem we haven't seen that problem personally seen it on a scale. OFS may have seen that more, but we haven't had that raised with us directly. But I appreciate the issue that can cause in certain circumstances.
Thank you, Gordon. I think we're coming to the end of our Q&A session, and thank you very much for your presentation and also for answering that kind of range of questions that were put forward. We're going to have a short break now for 10 minutes, which means we're going to reconvene at 11:20. So we're all going to turn off our kind of our cameras and so on, and we will be back here for the second part of the session at 11:20. Thank you very much. Welcome back, everyone, after our short break. Thank you for joining us for the second part of our session today. I'm very pleased to be opening the second part of the session by introducing you to Jo Nuckley. Jo is Head of Outreach and Insight for the Office of the Independent Adjudicator, or the OIA, as we refer to it. And today she's going to be speaking to us about trends in student complaints. So welcome, Jo. Thank you very much for being here today.
Good morning, and thank you for having me. I'm very pleased to be here talking on behalf of the OIA. So as Susan and Gordon have both alluded to, the OIA is the Independent Complaints Scheme for students in higher education studying at providers based in England and Wales, and that does include their overseas students at overseas campuses as well. And we are an ombudsman, not a regulator. We don't have our own initiative powers to go out and investigate things in the sector. Our role is to respond to student complaints brought to us by individuals or groups of students collectively. And we make recommendations to remedy individual cases, and then we try and draw out wider learning for the sector from those. We've got about 850, just over, member providers at the moment. So we do have a huge range of organisations that we cover and try and share good practice. But obviously what that might look like in different institutions that we cover can be quite different. If we move on to the first slide, some of you who are big fans of our annual report will have seen this one already. This just tracks the number of complaints we've been receiving year on year for the last decade or so. And as you can see, that is broadly speaking on an upward trend. And this is counting the number of actual complaint forms we receive from students. We also get inquiries that don't turn into complaints, and those are similarly on an upward trend. The number at the end there is our largest ever complaint receipts in a single year, and it excludes one very large group that we closed last year of around about 400 students on a creative arts course that was significantly disrupted by COVID. And if you're interested in that, you can find more about that in our last annual report as well. We often get asked whether this sort of rising number of complaints is something to be very alarmed about. I think there are different views on that, but I would definitely set that in the context of the number of students that there are. It's quite difficult to get an exact comparator for the number of students who are at providers that we cover. But if you look at HESA data, for example, as a broad comparator, you know, there are another 500,000 students in the UK in the time that that graph shows. So it's possibly not particularly out of sync with that rise in the number of students. If we move on to the next slide, I'm just going to talk a little bit about the types of complaints that we receive. So as you can see from this, most of the complaints we received, certainly in the last year, were either academic appeals, so students who've challenged a progression decision or a mark or a classification at the end of their degree, for example, or service issues to do with something that has been delivered or not delivered or delivered differently concerning their academic studies. If you look at the graph, you can see that we do have in the top left corner another category for non-course service issues. So if we saw something that was about complaints about accommodation or complaints about the careers service, some of those supplementary extracurricular areas, those complaints would be into that bracket. And I would say that our categorizing of complaints is much more of an art than a science, because students don't tend to make a complaint in a very narrow way. They describe the concerns that they've experienced in the way they've experienced them, so holistically. And we'll quite often see things that are about service delivery raised by a student in their academic appeal. Most of the complaints that we get from students acting as groups do fall into that service issues bulk, that 38%, and that is commonly students who have been studying the same course or the same module and who were impacted by the same event happening to that module. So if we move on again, on the next slide, if it's possible to have a favourite graph of the year, this is mine so far because it's a rather pleasing fish shape. This is showing what service issues and academic appeals have done as a percentage of our caseload in each of those years over the last 5 years. So as you can see, we historically have always had a lot more academic appeals than almost anything else that has come to us, frequently based on students' personal mitigating circumstances. And then over the last 3 years, we have seen that switch around. And obviously there are some fairly significant external factors which explain that, you know, COVID being the obvious one, industrial action being another. And there are some course, campus and provider closures accounted for in that as well. But as you can see, in 2022, we got exactly the same amount as a percentage from students about service issues and academic appeals. And I would say tentatively for this year to date, it looks like that graph is going to continue and cross over and academic appeals are coming back up again. But I am quite cautious of comparing a partial year to those complete years because the way that complaints comes into us does fluctuate over the year. So we'll see where we are in a few months' time. And obviously I'm always up for a conversation with people. If you are seeing something in your institution that's quite different to that, we'd love to hear from you and hear about it. Probably we're speculating the resurgence of academic appeals may well be as a result of removal of no detriment policies that applied during COVID. And there's also something to be said, I think, about the complexity of students' lives in general. and the very difficult juggling of personal circumstances and study and employment increasingly that students are trying to manage. If we move on to the next slide, I've put on here, again, this is from our annual report, a breakdown of the outcomes of complaints we concluded in the last year. So about 30% of students, we don't reach a decision because a lot of students come to us prematurely. So they may well come back to us, or they may well go back through their procedures at the university or college they're studying at and get a satisfactory outcome. And we are not the first port of call for students. We are very much the end of process, last chance saloon aspect of complaints handling, and we should only get a certain percentage coming through to us because providers should be sorting issues directly in conversation with students. The largest section on that is complaints that are not justified, which does rather sound quite judgmental and is terminology that we try and move away from a little bit, I think. It doesn't necessarily mean that a student didn't have a valid point of any kind. It doesn't mean their complaint was totally unfounded. Some of that section will be that a student had a valid concern, but their provider has already responded to it in a way that we thought was appropriate. And then in that top quarter, you can see on top right, about 25% of our complaints are, generally speaking, favourable to the student. But what is quite interesting in this space is that when we think only about academic appeals, that top quadrant of favourable outcomes is much closer to sort of 15 to 18% over the last 2 or 3 years. But when we look at service issues, the percentage that we uphold for those students is closer to 30%. So we are upholding quite a few more of the complaints that come to us about service issues than we are about academic appeals. And perhaps that is because academic appeals processes are really very well established in a lot of providers, and there is a definite clear routine and there is a sort of familiarity about them, whereas perhaps service issues might be new, novel, a bit more challenging to deal with, and there is something about the defensive response, which I'll talk about in a moment. If we move on again, these are the kind of things that students are typically raising with us that we would describe as a service issue complaint. Our view is that students absolutely do not need to say to us that this is a consumer rights issue. They don't have to identify it in that way. They don't have to refer to the CMA guidance. They don't have to quote legislation. Our view is that all they need to do is talk about what has gone wrong, what they were expecting, what they want done about it. So it's rare that students will articulate it in that way to us, but they do increasingly talk about the fees that they've paid. And I know there's quite a lot of debate in the sector about whether students ever really pay their fees, if they don't pay them all back, all of that. But for most of the students who complain to us, they definitely see their tuition fees as a very real debt that they expect to pay back, and that is something that they are very conscious of. In service issues, we probably see more being about non-delivery, delayed delivery, change delivery, than being very specifically about the quality of delivery or about the standards of the education that students are receiving. I think it can be quite hard for students to know what a quality or the standards should really look like. Whereas, you know, if something just doesn't happen, that is much easier for them to identify. And what we do see is that complaints in this sort of space, often students don't raise them very promptly. They'll quite often wait till the end of the academic year, and it is often when they have gone home and spoken to friends studying something similar somewhere else, or talked to their housemates about things in a different course, that they start to realize that what they're getting is different in some way, and they start to question their experience. We've outlined the approach we take to all of these kind of issues, and specifically our approach to COVID cases and disruption also caused by industrial action on our website, and there are lots of case studies. So I'm not going to go into that in much detail because it's all there. But broadly, our approach has been to think, have students been disadvantaged academically by what they're talking about? Have they been able to progress? Have they been able to achieve the award they expected to? but more widely than just a piece of paper with a qualification on it, did they get the learning they expected to? And was that broadly equivalent to the usual arrangements? And if not, what was done? And we take a sort of an approach of reasonableness and think about what the students, the impact on the student has been and the consequences for them individually. So if we move on again, I think one of the things we would draw out as learning about service issues is that providers sometimes get lost in the weeds of proving who was right. And it's not always necessary. You might want to unpick that for yourselves because it's useful to get that learning, but it's not always necessary to establish who was right on every single factual point in responding to a distressed or concerned student in front of you. It is difficult for a student to challenge the authority of a provider if they have come forward with a complaint. This is feedback that is useful to you, and that where you have an ongoing relationship, it is important to keep that relationship as positive as it can possibly be. We do see quite a lot of cases in this space where providers or individual staff members at providers are quite willing to say, yeah, that wasn't quite as we'd hoped. We'd like to do something differently in the future, to acknowledge that students' concerns are valid, but then it falls down a bit at the remedy stage, and not everybody is sure where authority to deliver a remedy, particularly a financial one, might come from. I think in these kind of spaces, because students, as I say, often leave things until quite late on, it's quite difficult to do much at the end other than think about a financial remedy, which is quite different to the rest of our caseload in terms of, you know, being able to rehear a disciplinary case. There's something practical there, but here it is often financial. But it's worth remembering that students don't always want the same thing. You know, we've seen in the pandemic lots of changes to assessment being made, and we had a complaint from a student who was devastated they didn't get to sit an exam. They really wanted to sit it. They felt only a mark from an exam was going to be valuable when they went into the world of employment. We have seen complaints from students both about the majority of teaching being delivered online and that being not what they expected, but we have also seen complaints from students who were very happy with the online teaching, found it more conducive to their learning, were happy that they could repeat things and dip in and out and speed things up for some of them, and they were very cross that they were expected to return to campus and come into campus and have that sort of physical experience wasn't what they wanted either. So not all students are the same. If we move on again, I'm quite conscious of time, and I know that people love a case study. So there's a lot of text on here, which we might not have time to really look at in detail. But essentially, I thought I'd give you an example. Here is a student who makes a complaint that they did not get what was promised to them. They were on a course that was really quite practically based, arts based. They expected to get a lot more hands-on experience than they had. A member of staff had left during the year, and so there was a gap that a specialism was not being delivered. And also, they were not going to be able to participate in their end of year show because it was happening after their visa expired. So if we move on in terms of the next slide, what we looked at and our approach is to consider what information was gathered by the provider when they were responding to the student's complaint. And we were looking at information in the prospectus, information that was available from open days, their pre-arrival correspondence, module descriptors. And in this one, we really did see a very strong emphasis on practical skills. It was written in there. We've also had complaints where language in prospectuses can be quite flowery, shall we say. So we had one complaint recently where a particular aspect of the course hadn't been delivered, but the phrasing in the prospectus was, this is a part of the DNA of the course. You know, it was expressed to the student in such a way that was fundamental to the course. Here in this example, we had the expression that the culmination of the course is the degree show, the public show, which this student wasn't able to participate in. So this language matters, and where we think there's ambiguity in it, we are more likely to interpret that in favour of the student. That said, In this case, you know, we had a student who was had some very reasonable expectations based on what they've seen. We do have students whose expectations are not necessarily reasonable. They are formed, their expectations, not necessarily from anything that's been said to them, but assumptions and wider society. One that sticks in the mind for me recently is a student who joined a business master's course, mainly because they thought they would get to play on the university's very strong football team, and that they hoped to break into Football League in that way. So the course had nothing to do with why they'd started, and their complaint was they didn't get selected for the team. So that was quite an interesting variation for us to deal with. So in this case, if we move on, just so you've spotted that on the slides there, we decided that this student had a very valid complaint. They had some other bits that I've not summarised on here that made it partly justified rather than fully justified, but the core of their complaint was very soundly based, and the provider's offer of £750 for not delivering some studio space and for feedback being late really didn't encompass properly the gap between what had been promised to the student and what they had experienced. I know that I'm running to time. I'll just very quickly move on because you can pick these up, I think, when you get the slides. The other case I would have talked about had we had more time was just an example of where confusion about fees was the issue, and this one was not justified in the end, because although there had been some confusion for the student, there was a conversation that was confusing, and the student believed they were being told what the amount of tuition fees outstanding for the entire course would be, and in fact they were being told what was outstanding to date, and that there would be significant further fees after that. And in this case, actually, the university had put all of this information on its website, but because the student had taken quite a different path than expected, because they had changed courses twice, moved from part-time to full-time, the university was acknowledging that actually it would have been better practice for it to have written very explicitly to the student each time they made a transfer, setting out what that now meant. And the student, the university offered the student £2,000 in compensation for this confusion and distress, which we felt was a good and reasonable amount, and perhaps somewhat higher than we've seen in other cases. So I'm sorry to rattle through at the end, but I know that we're quite keen to keep to time, so I will leave it there, but our contact details will be on the slides, and if anybody has comments or questions or things they want to reach out to the OIA about afterwards, please do. Thank you.
Thank you very much, Jo, for that fascinating insight into trend data and the really useful summary of good practice and also the case studies. I'm sorry we did slightly run out of time, but I know the slides are going to be circulated afterwards, so people can kind of follow up on the details of those. We're now moving to our panel session, and I would like to introduce David Smyth, our Director of Monitoring Intervention, who is going to introduce you to our panel members and also facilitate our panel discussion today on protecting students' consumer rights, what more could and should be done. So I'm going to hand over to David now. Thank you.
Thanks a lot, Rowena. I'm really glad to introduce our panel for this discussion. Jo has very kindly agreed to stay on for the panel discussion today, and I've seen lots of questions coming in while she's speaking, so that's great that she's going to stay here. I'm also welcoming Emma Leach, University Marketing Leader, who was formerly the Director of Marketing and Communications at Nottingham Trent University. Nisha Arora, the Director of Cross-Cutting Policy and Strategy at the Financial Conduct Authority, as well as a member of the OFS's Provider Risk Committee. And Amy Yeoman, the President of Education of York St John's Students' Union. We've got more information about each of those on our website, and I'm just looking in the, yes, I'm just going through the pictures to make sure that everyone's here, but everyone is here. That's great. So thanks to all of you for coming. Please do keep on sending questions in for individual panelists or for the group as a whole. But I think a first question that I'd like to ask each of you is really just to what extent do you think that students' consumer rights and those being challenged is an issue? To what extent do you think this is a problem now? And I'd like to start, I think, with Emma for that, please.
Thank you, David. I think it continues to be a problem. I think we'll see it increasingly becoming a problem. And I think those of us who've perhaps worked in the field for a while have been able to see the changes and the tightening and the focus on this. It's not going away anytime soon. My field is marketing and communications, and I've seen firsthand student complaints come through the system and how we respond to that. But there is also a tensioning off institutionally in most instances with how we as universities respond to some of those issues. So for me, it is an issue. It's one we need to be ever mindful of, but there's also something about how we inculcate a culture institutionally so that everybody understands fully their role in delivering and making sure that we don't fall foul of the regulations. There's an awful lot in there. I think the ambiguity around words like reasonable is sometimes very difficult for us to navigate as universities particularly. I'm going to leave that there because I'm sure colleagues will have interesting perspectives on this one.
Thanks a lot. Nisha, can you give your views, please?
Yeah, no, sure, sure, David. And if it's all right, I'll give my views from a bit of an external perspective, particularly from financial services where I currently work. Because both, financial services, higher education, very, very different markets. But I think essentially in whatever market consumers, students play in, they want the same things. They want good value products and services or courses that meet their needs and expectations. They want information they can act on, and they want really good customer support. And consumer protection, as we've heard today, plays a really important role in that. Now, in financial services over the last few months and years, actually, we've been debating whether consumers are sufficiently protected and whether the markets are working in their interests. So as we think about higher education and what more could and should be done, I think it's helpful to just to outline briefly some of the issues we saw and some of the changes we've made in response to that, because that might be a bit of food for thought for you. So we saw harm from poor conduct, from poor communications that were difficult to understand, products not meeting the needs of consumers, poor customer support, and sludge practices that effectively got in the way of consumers making decisions. So last year we introduced something called the consumer duty. It's a new principle. It replaces for retail markets the old treating customers fairly principle, and it sets clearer and higher standards for consumer protection and make sure that firms really focus on consumer needs, including their vulnerabilities and delivering good consumer outcomes. And if you take a look outside of financial services, actually what you see is many of those concerns driving other regulators and the government to increase consumer protections in markets. There's a lot happening in other sectors. And I think then that does beg the question even more of what more needs to be done in higher education. And I suppose when we look at the complaints and the issues here, although we've heard about it, there've been many positive developments around the application and development of consumer law in the sector. I certainly don't think that's job done. I mean, look, the concerns that are being highlighted by campaigners, students, really do question whether consumers' interests are being served, whether they're getting good value from their courses and effective, clear communications, and whether, importantly, their differing needs and vulnerabilities are being understood and addressed. So obviously, we don't have the answer today about what needs to be done, but what I would say is that as we did in financial services, I think a debate about this is really essential, and it's really timely and welcome that this is restarting. I think that debate needs to establish whether students are experiencing harm, the drivers of those harms, whether the level of consumer protection is appropriate for both now and in the future, because markets just keep developing and changing very quickly, and whether the sector is consistently delivering good outcomes for its students. And if it isn't, then we've got to consider what further protections are needed.
Thanks a lot, it's really helpful. Amy, grateful for your views on this.
Yeah, thank you very much. So students are paying for a service when attending university, and even though many people seem to think that students don't see themselves as consumers, they actually do expect to get what they're paying for. And when we consider students as consumers, we really should be thinking about the quality of education and university experience that they receive and whether it aligns with expectations that have been set out by the university. So for example, recently I carried out a piece of work through my SU, which I then subsequently presented to our uni exec board, which looked into hidden course costs at university. And this was based off a number of students coming to seek advice from me, expressing that they were disappointed, that they had to fork out for additional costs when they were paying £9,250 a year. And kind of in the ever increasing neoliberalist higher education environment, students are beginning to understand that coming to university is a transactional process. They pay lots and lots of money and don't take that decision lightly. And therefore they expect to get their money's worth in their consumer positioning. And our university did actually take on board the insights from that survey and kind of improve the student experience from that. I'm also a member of the OFS's TEF panel, which assesses institutions on their teaching excellence, and being part of this really rigorous process assures me that there is a regulator, somebody independent from the universities working in the interest of consumer rights, ensuring that institutions satisfactorily meet B and C conditions, praising institutions that excel and have outstanding provision, but also holding firmly to account institutions that require improvement in their provision. So student experience and student outcomes are at the heart of that, and therefore, student consumers can be reassured that there is an independent body looking out for them, treating them as consumers.
Thanks a lot.
you.
That's really helpful. And Joe, I was going to bring you on this, but actually I'd like to ask you as well about that point that Amy was making about students increasingly seeing themselves as consumers. And I'd be interested in your thoughts on whether you've seen a shift in that, and the OAA's seen a shift in that since its formation.
Coming to that point, I think it's not that people who complain to us articulate it explicitly as that, but yes, we definitely see a lot more references to the fees I've paid for this than we used to. And partly, obviously, that was the shift from £3,000 to £9,000 a year. But I think there's also something about the financial pressures that lots of people are under now, and just the way that people are much more conscious of that. It is definitely a factor in how students articulate their complaints. They do see it as an investment, and the students that we engage with are incredibly dedicated. Every now and then, you go and tell people what you do, and they still have a vision of students as being 19-year-olds who are asleep in bed and getting drunk every night. And the reality is that we see students who are extraordinarily focused on what they intend to benefit from in their HE, and what they feel they have been promised and what they expect to get from that. And they are engaged and willing to engage. And I think Amy's used the word transactional is an important one. Transactional is often seen as sort of having a negative connotation, whereas engagement is seen as very positive. But actually, all of this for me boils down to the need to talk to your students and to facilitate that very engaging dialogue with students as soon as they're through your door about what it is they're expecting. And so you can make sure that you're meeting and steering those expectations. Sorry, that was probably quite a woolly answer to that question, but I think we're thinking about complaints, that dialogue before they get to the point of complaint. I think most students would rather explore the options and get what they expected delivered than be compensated financially for something that wasn't delivered. That is the sense we have. It is not students saying, oh, I can get some money back here in the complaints that come to us. They've taken the time to complain because they wanted what they think they were promised.
Thanks a lot. That's really helpful, Joe. And I think to us that's probably something you see in lots of areas that are much more, have always been seen very clearly as transactional, is that people don't usually, as the first step, start trying to seek compensation. People want it to be a functional relationship where they get what they were seeking in the first place. We've had some really interesting questions in. One, and I'd be interested, maybe Nish, in your thoughts on this with the parallels in your industry as well. So there's a question about how students' representative organisations can help students in understanding and kind of getting their consumer rights.
Yeah, look, I mean, in the financial services sector, certainly we work really closely actually with a lot of consumer groups, so whether it's Which, Citizens Advice, the debt advisors. I actually think one of the most productive things is, if we look at a regulatory system, we've talked this morning, haven't we, about OIA and OFS and trading standards and CMA. The bit we didn't really talk about actually is consumers in that element, and then the role of consumer sort of representation groups and organisations. And I think they do play a really strong role there in keeping us on our toes, keeping the regulators on our toes, challenging us, helping to represent sort of the overall student interests, passing us information actually that helps for us to understand things, and then also, explaining issues, and being a bit of a conduit for messages about students and their student rights. Because when I was working at the CMA in the higher education sector and many other sectors, people don't know about the they do know about the OFS if they're in this sector, but they don't know about the Financial Conduct Authority and CMA and all of those weird acronyms out there. But so what they want to hear from and people they understand, and they want to be able to, as Gordon said, if they pick up the phone to Citizens Advice or go on the website, understand that. If students want to speak to their student unions or representation groups, that's who they communicate with, that's who they understand. So I think it's really good when we see regulators working in part, and OIA and adjudicators working in partnership with all of those organisations to help the information flows.
Thanks a lot. And Amy, any views on that question?
Apologies, can you just repeat the question? That's all.
So what role do you think the student representative groups can play in kind of helping individual students understand and kind of get their rights as consumers?
Yeah, I think it's quite difficult, and this is something that I wanted to touch on later, actually, in terms of student representatives obviously know the ins and outs of, what will be constituted as a complaint to the OIA, for example, or what their rights are as consumers. And I think normal students that, perhaps aren't within the students' union sphere need to kind of understand that a bit more. And I think perhaps there needs to be more communication from students' unions as an independent body to students, to understand their rights as consumers. I think it's not very clear at the minute. And obviously the university is probably not in the position to do so. So I think that student representatives really do play a part in that.
Thanks a lot. And Emma, any views on that?
Yeah, I'd agree. I think it's really important that student unions are on the front foot, but also that they feel they can work with the university, because I think everybody is on the same page in terms of wanting to deal with issues as they arise, rather than at the end of a really difficult process that impacts on students, their results, their mental health, all of those critical issues. So for me, partnership working really, particularly at critical points in the cycle, can work really well, so that students fully understand how to get support, where to go, what their rights are, and also who's there to advise and guide them. So for me, really important role. And I think Amy nailed it with her answer.
Thanks a lot. And Joe, I don't know how much you see this in terms of the case of the county, whether it's visible to you how many people are relying on those sort of support groups.
It's quite difficult to quantify, but we engage directly with student unions and other representative bodies ourselves. And we have in the last year run workshops for student union officers and advisors, specifically focusing on sort of consumer rights and exploring with them the kind of approaches they take. And there is a lot of variety in what capacity student unions have to provide in this space. I mean, firstly, there are a lot of students studying at providers that have no union structure anyway, and find it difficult to get independent advice. But where there is independent advice, sometimes student unions are able to then advocate on a complaint, and sometimes it is more that exploratory work. We think both of those are incredibly valuable. I mean, I'd echo what everybody else said. It's so important that students can get context-specific advice about their own institution and its procedures. It's really helpful when those advisors do have a working knowledge of other options and the different routes, which includes us, but might include other ways of pursuing a concern, and that they're able to give that advice to students in a timely way. It is really critical part of this whole piece.
Thanks a lot. And actually, while I'm with you, we've had some sort of specific questions that came up while you were talking, so I was going to touch on one of those now. So there's someone who said that they're presumably working in student union advice services, and their sense is that cases are becoming increasingly complicated, and that providers are often not meeting the 90-day suggested turnaround time for dealing with formal complaints set out in your good practice framework. So they were sort of wondering, is this something that you've noticed as well?
Yes. Yes, in short. There are various reasons over the last couple of years why individual providers have found it very difficult to meet deadlines at various different points. But the conversations we have with the sector are showing that providers are dealing with increasing numbers of complaints, academic appeals, requests for additional consideration, so mitigation and so on. You know, we hear from providers who are getting 20 or 30,000 requests for modules to be considered, you know, as special circumstances applied to those in an assessment period. The work is rising, and perhaps providers are somewhat on the back foot in resourcing and responding to that. I think it is rare, really, that we see a provider simply delaying for the sake of delaying. I don't think that is what is happening. I think it is challenging in resource and getting providers to put that resource in the right place, and it can be quite difficult, I think, when you have high volumes of concerns coming from students. If you don't resource the early part, then you will have to resource the end, the formal complaints process. But making the decision to put resource into that early stage is a challenging one, because you risk always having this tail of complaints that have already escalated. So yes, it is an issue. For us, it is critical that providers who are facing those delays are keeping students informed about how long things are likely to take. It's one of the reasons I put in the slides about staying solution focused. There is some benefit in some cases of saying, well, skip to the end. If we upheld this, what would we offer? And what is the problem if we offered that now, rather than making a student wait and go through all those processes? That's not always appropriate. You know, I'm not suggesting that you can just skip to the end of a disciplinary process, but some of these concerns that, well, I didn't really feel I got this, if the solution you would get to is, hey, would you like to sit in on auditing that module again next year? Or would you like to have some extra one-to-ones on that? And we could do that. Try and think a bit practically about some of those.
Thanks a lot. There's another question that's come in, and maybe Emma in the first instance here. So what do you think that prospective students want in terms of information about higher education courses before deciding where to go?
So I didn't catch the last bit of your question there, David. Can you just repeat that for me?
What information do you think students want to make their decision about where to go in higher education?
I think they want everything, and over the past couple of decades, you know, the influencing factors on student decision-making behaviour have remained largely constant, but certain things come in and out of fashion and favour. Employability is a huge focus. And for very many students, it's critically important that they understand where a course will take them in the long term, particularly as cost becomes increasingly important. So related to that practical elements, the support that is going to be available in institutions, we're seeing much more interest in student support services, and universities, I think everywhere, are struggling to keep up with that. I think students expect and want transparency, but from the university perspective, there's also that understanding that we have a duty to ensure students have around what their part of the contract is as well. So people, I think increasingly the shorthand has become, oh, I'm paying for a degree, but it's a little bit like me paying gym membership and not going. It doesn't happen on its own. And that's really difficult, I think, sometimes for students to understand. I think the other interesting area that we haven't touched on in terms of either complaints or information demand is particularly parents and carer audience, but particularly parents who are increasingly involved. and heavily involved, particularly I would say when students are levelling the kind of complaints that make it through the system. So that adds an extra layer of complexity to what we're trying to do from a marketing and comms perspective. And perhaps Amy's got a different perspective on some of this, but it's a really interesting question.
Yeah, so I'd like to bring Amy, and then that's just something you said that I'd like to pick up with people too. But Amy, your views on what kind of students are looking for in the information before they decide where to go.
Yeah, I think an increasingly big thing that students are looking for after COVID is the social side of university, the non-academic side of things, and what kind of university experience they can get from that side of the university. So, for example, Students' Union, I'm a bit biased there, but support services, well-being, what's going on within the university campus. They do still look at the course, I think, that's really important. And like Joe alluded to earlier, they are really interested in the courses, and they understand now more about that, the importance of employability within a course and becoming graduates in the end, how that will help them become good graduates. But yeah, I agree with Emma what she said.
Thanks a lot. And then I want to pick up, Emma, that point you raised about sort of gym membership. Parallel, which I've heard before, is an interesting one. So there was a sort of related question we got, which I'll sort of read out. So it says, since the Consumer Rights Act came into effect, there's been a change in students' perspective in viewing themselves as consumers, sometimes to the extreme end, where some students see it as their right to receive a degree without necessarily engaging in any study on their part. Is it possible that we are seeing an increase of complaints due to the fact that some students no longer view university education as predominantly one of education, but rather as a consumer? And I'd be interested, Nisha, maybe in your thoughts on this.
Yeah, no, actually, we had parallel discussions in financial services around the issue of consumer responsibility, and a number of commentators said, you're increasing consumer protection. Does that mean consumers don't have any responsibility? Does that mean it's all on us as providers? And our answer was no. Consumers have responsibility. They have responsibility for making decisions. They have responsibility and obligations under a contract. However, the conditions for making those decisions need to be the right ones. And from our perspective, it's providers have to take greater responsibility in the financial services sector to make those conditions right. So that is around timely, good, effective information that people can understand so they can make those decisions. It is about suitable courses or products and services that meet needs. It is about good support that helps people through those decisions. And it's when those conditions are right, then students, consumers can take responsibility and make the right decisions.
Thanks a lot. Joe, do you want to come in on this?
Yeah, I mean, I'm reflecting that we get very, very few complaints that really boil down to, I paid for it, I want a certificate. And that might be because the level of effort, and it shouldn't be too traumatic to go through a complaints process, but it involves some effort and some articulation. And so the students who are likely to end up with us are perhaps those who are more dedicated, more engaged, more likely to engage in the first place. I mean, there's a difference between making a complaint and sticking your name on a petition, for example, the qualitative difference there. But I think the other things that students are wanting in advance that we probably see most of in the complaints, other than the things we've touched on about fees and exactly what things are going to be delivered and the accreditation type issues, tend to be around how flexible a course might be, specifically thinking as well about adjustments for students with disabilities, and students are increasingly wanting to know what assessment looks like and wanting to make choices about, I do or don't want to engage in exams, I do or don't want to engage in coursework. And I think students' expectations, the way that I would say they shifted, and perhaps that is due to consumer mindset, or perhaps it's just the way that we all engage with everything now. All our television is on demand. Everything in modern life is designed really to
to be accessed at your convenience. And I think students perhaps have very high expectations of a very flexible approach to what they're engaging in that perhaps the sector hasn't quite caught up with in delivering, or has not articulated that no, that isn't going to be what you experience. I think students are still, for example, told by their parents things like, oh, just apply to this course, and then when you get there you can change, you know, and that's quite difficult, I think, for then providers to deal with if students are sort of expecting something that their parents are telling them. And we are now at the point, obviously, where the school leavers who are going to university, home students, it's more likely that their own parents did go to university here in the UK than ever before, because we're just getting to that generational point, and they will have preconceptions and ideas from 20 plus years ago that are quite difficult then to counter. And I think the point you sort of alluded to about engaging with parents and other carers with specific information for them is something that's really important.
That's a really interesting point, actually, that having parents who went to university is, I suppose, is both positive and negative. So you've got the insight, but the risk is that the insight is wrong.
Just preconceptions that might be a little bit out of date. Yeah.
Yeah, no, that's really interesting. Actually, one more question again that came through for you in particular. You mentioned when you were speaking earlier about getting defensive responses from some institutions. It's been a question if you can kind of unpack the sorts of thing you mean.
Sure, I think it is that you can get quite defensive responses. I mean, anyone who receives feedback that isn't, thank you, that was wonderful, is going to have a negative reaction to it. Complaints are an emotive thing to receive. And I think as a sector, you know, there is a lot of talk about the demands on frontline staff, whether that's academic staff or library services staff or other services staff. And I think particularly in the last few years, you know, in the pandemic, say, when your academic staff had to make a sudden shift to online delivery, which they weren't used to. They probably had kids at home in the background. They might have had sick parents going on over here. They feel they've worked their socks off to give you the best thing they could, to then get a complaint that is, but that wasn't what I wanted, and it's not okay, it's not enough. It feels very personal, and that's where you get a very defensive first line response. And it is necessary for people receiving those responses to just take themselves out of it. And the other way I think that providers can be defensive and fail to engage with the realities of what consumer rights give them is that response where it's like, well, this happened because of that situation. That situation was not of our making, so we're not going to engage with the solution. And obviously, you know, everything we've been talking about today is highlighting how that is not an appropriate response, but it is a very human one.
Thanks a lot, Jo. That's really helpful. Particularly as we're coming to the last 10 minutes or so of Q&A, we had a question which is more, it's sort of positive, forward-looking. So the question we got was just what actually have you seen that works well in terms of complaint systems in providers? And can I ask, I'll come back to you on this, Jo, because you'll see a lot of this, but I'll give you a rest and go to Amy in the first instance.
Yeah, I don't really see it from a university perspective. I see it more from a students' union perspective. Our advice coordinator works a lot on complaints that go through and supports them going through to the OIA. And I think it's really important to have that independent body from the university to support students in doing so. I think, you know, we know the ins and outs of the university system, but we are separate to them, and we can offer that kind of objective, you know, outside viewpoint when they're writing a complaint. I don't really have anything more to add than that.
Oh, that's really helpful. Emma, your views on that?
Yeah, I think part of that is around the clarity of where people go in the first instance and how engaged, particularly, you know, marketing and communications colleagues amongst many other professional services are in engaging with internal stakeholders, so that wherever a complaint perhaps enters the organisation, it's channeled quite quickly and effectively to the right place. for a solid solution. I know a number of institutions, including my previous organisation, have now got kind of dashboards in and inquiries management, so that actually there's a better way of ensuring that inquiries and complaints are progressed, get to the right place quickly, particularly if it's a multiple parts. And I think one of the comments from our previous panelists was very much about the complicated nature. And I think that complexity and ambiguity are totally mitigate against fairness. So we have to be as clear as we can at making it obvious where people need to be. We need to look at the crunch points through the cycle as well and make sure that we're on the front foot with communications that allow students to get the support they need at the time of need. And we need to be clearer, and sometimes I say this to be mildly controversial depending on who else is on the call, but those of us in a comms or a marketing type role in universities have to be able to push back to perhaps some colleagues in some areas that are very, very risk averse unless anything is written in an incredibly academic way. And sometimes that writing is not accessible to the people we should be helping the most. So that is a constant challenge. I think all colleagues that I've ever met in universities are willing to support and engage, but the methods do vary. And I think the other thing is one size doesn't fit all. So we need to be able to take tailored approaches that are multi-channel, include face-to-face, work in partnership with Students' Union, and really just ensure that nobody's struggling because they don't know where to go and who to get advice from. I think that's the absolute goal for all of us.
Thanks a lot, it's really helpful. Nisha, views on this?
Yeah, I mean, I agree with a lot of that. I mean, in a university context, you know, as Susan mentioned earlier, there's power imbalance. I think a lot of consumers are really fearful of complaining. They don't know where to go, as people have said. I think that's, you know, that's writ large in the higher education context, where say that you've got people who haven't got that much experience, not confident in explaining, in complaining, and I say that sort of power imbalance. I think what that then means is even more essential that providers are proactive in their communications with students about how they can complain, and then when they receive those, that they are receptive and engage, and they don't put blockers in the way, and they don't put people off, and they don't put problems there that put people off, because they will be put off very easily, and it's not a good outcome, because you either get them people going to the OIA when they could have had it quickly resolved at the university, or they're put off. And it's, you know, and we have discontent and a lack of trust and confidence. So being proactive, being engaging, being open to that and resolving quickly, and making sure your processes are easy to navigate and to access. And then I think the final thing is that, and I'm sure there is, but a really good feedback loop between the things that happen, the problems that occur, and the improvements that the provider can then make as a result of those.
Thanks a lot. And Joe.
I'm so happy, but Nisha's just stolen my point there. I was like, I must talk about feedback. Yes, sharing that learning back again afterwards, sharing it with your student union and other services that are advising students about complaints, getting that virtuous circle going is really, really important. And all the other points that people have mentioned about the clarity and simplicity of the process, you know, really resourcing that early stage, thinking about mediation style approaches, conversational style approaches, and even simple things can make a difference. I think one of the things I would say is that providers can be a little bit reluctant to set up forms, for example, that really guide students on what to say in their complaint. There is a sort of reluctance to tell students what kind of evidence would be relevant and useful. And then you end up with a more protracted process, either because students don't quite know what to do, and some of them have written submissions to us that are longer than the PhD submission that they're complaining about. And others get into a more protracted process because they had evidence that would support their concerns or is relevant, but they didn't know to supply it. And so the process has gone on longer. That there is this sort of, oh, well, we won't tell them how to make a good complaint because then we'd have to uphold it, which again is sort of quite a defensive position. What you want is to tease out the facts and the truth so that you can decide what has gone on and move forward from it. So I think being more transparent about what is relevant and helping students to do that, and if there's no SU to help them, the provider taking on a bit more responsibility to that can be incredibly valuable.
Thanks a lot. We had a specific question for Nisha. I was just wondering if you could say a bit more about the new consumer duty and how it might be relevant for students, and I guess for providers in particular.
Well, yeah, as I say, I'm happy to talk about that at length, but I won't. Where did that come from? It came from a debate about the duty of care, actually, and what I wanted to do is to move that debate from do we need a duty of care or not, and have we got one, to actually what's going on in the market, what are the harms, and we looked at the harms. What we've come out with is something that's based on outcomes, and it's a sort of proactive requirement on providers to provide good outcomes. And what we're trying to do is say to providers, look at your whole consumer journey, as we've done today, and we've talked about that, haven't we, from course provision through to communications through to support. Look at that, put a consumer lens on it, start with your consumer needs, in this case student needs, and think about throughout that whole journey, what are consumers' needs, what do good outcomes look like, and how can I help to ensure those good outcomes are being delivered for whether it's my students, my customers, and then being able to test those and make sure those outcomes are being delivered using evidence, data to test that and continually improve. So it's a real shift on a bit more of a positive obligation, say getting the conditions right so that students, consumers can make decisions, but a real focus on outcomes and starting really importantly with your consumer needs. So I think, as I say, some of the read across may not work, but I think there's quite a lot in there that would be worth providers and the higher education sector thinking about as they take the debate forward on consumer protection.
Thanks a lot, Nisha. That's really, really helpful. We're coming to the last few minutes before we close. So I wanted to kind of just give an opportunity. Is there anyone, any of the panelists who had any points they particularly wanted to make, any observations they particularly wanted to bring that they haven't had a chance yet? I think I saw a nod, so Amy, let's go to you first.
Yeah, thank you. I just wanted to talk a bit about, I do research on international student experience within higher education. And I'm quite interested in whether their experience within English universities, higher education, reflects the high fees that they're paying. And these students are becoming more and more aware of their monetary value, their cash cow status really within HE, and it's kind of alluded to in that paper published by the OFS noting the over-reliance on international student fees. And a lot of international students come to me as a SAB officer and tell me that their experience is not what they thought it would be. It doesn't live up to their expectations. I just wonder if anyone else had any thoughts on that.
Emma, can I put you on the spot?
You can, yeah. I think different levels of complexity, and it also varies by nation. I think a lot of that is also how proactive an institution is in terms of providing that support up front, and also how we as institutions manage and support our agents so that there isn't any mis-selling and there is clarity there. And I think it's also about the academic and pastoral support that an institution provides from the off to those students, and how they identify any vulnerabilities or gaps that would perhaps impact on their performance and then create problems downstream. So I think there's lots we can do in that space, and it's a really important point that Amy's raised there. I can see Nisha has her hand up on this as well.
Thanks a lot, and Nisha. So really love to hear whatever you're going to say, but I'd also be interested in your view on what Emma just said about paying particular attention to agents and your views on when you've got sort of third parties who are doing some of the outreach or some of the making some of the commitments to consumers in this context.
Yeah, no, and I think, I mean, every on that last point on agents, every sector, financial services not least, that have outsourcing, agency arrangements, and again, ultimately it's the responsibility of the provider to make sure those are put in place, and they're not abdicating the responsibility. It can make those sort of chains can make things more complicated, but there is a sort of responsibility and a clarity around roles and responsibilities really, really important, and not, as I say, fobbing people off if it's outsourced. I suppose going back to, if it's right, David, just making two related points, I suppose, on international students, but more widely, and then sort of vulnerability, because vulnerability is not something we've talked about today, and I think it's a really important issue, given the complaints we've seen. So first, on different outcomes, one of the principles we've put in the consumer duty and our vulnerability guidance is to look at different outcomes for different consumers, and sometimes consumer protection law can kind of dilute that by looking at an average consumer test. And I think one of the things providers could usefully do is look at the different outcomes different students, whether it's international students or other types of postgrad or other students, are getting, and thinking, are there different outcomes, and are some getting worse outcomes than others, and if so, why? So are international students, to Amy's point, getting poorer value compared to others? I think linked to that, one of the complaints through OIA and others is certainly around vulnerability and the impact on mental health and well-being. And look, I'm just going to quote you a bit from our Financial Lives survey. In May 2020, 40% of students had a mental health condition or illness, or had one over the last 2 years, and that's compared to 28% for the UK average. We also see higher degrees of low financial resilience from students compared to the rest of the population. Now, one of the things that we've done at the FCA, and many regulators have done, is to establish sort of guidance and principles around the treatment of vulnerable consumers, requiring firms to understand the different characteristics and needs of their consumers and have the right systems, processes, staff capability in place to provide and respond to that and support students. So I think the one thing I would want to say is enough being done in the sector to really understand different needs, different student outcomes, different cohorts of consumers, get beneath the bonnet, understand their needs, and be able to respond to them in different ways using, as I say, data, staff capability, skills, and processes.
Thanks, Lorna. We've got sort of 2 minutes left, so I'll give that to Joe. So, any thoughts in general? But I think in particular, it'd be really helpful to think about that, think about different groups of students, vulnerable students, international students, and their needs.
Sure. So in all of our complaints over a number of years, international students have been disproportionately represented to us. The same is also true of students who've declared a disability. And I think what is important around the context of that is that we also know that disabled students are less likely to raise their concerns than general students, in as much as it's a very challenging process. They can be put off, they want to focus their energy on their studies, they don't have support always in place to pursue that. So that is a worry. And when we speak to students' unions, we hear that international students are frightened of raising complaints because they believe that a provider might retaliate and cancel their visa. Perhaps no evidence for that, but for me, there is something around the complaints that you don't get from those groups as well. I think it's really important that providers think about if they are not getting complaints from those groups of students, and that is more worrying perhaps than getting high numbers of complaints from students who are definitely have those qualities of vulnerability.
Thanks a lot, Joe. That was incredibly helpful. So thank you to all members of the panel. I think we had really interesting range of insights there, and that's reflected in the volume and range of questions that we got as well. So I'm going to close here and hand over, I think, to Susan to close the session.
Yes, you are. And from me too, thanks very much to the panel. That was a really interesting and thought-provoking discussion, and we could have taken it off in all sorts of different directions for the rest of the day. So perhaps some issues there we will come back to. And thanks also to earlier speakers. It was really helpful to hear more detail from Gordon about the CMA's revised guidance. And of course, it's always fascinating to look at patterns of OIA casework. So thanks to Joe for sharing that with us. During the morning, there have been very many questions, and we've not managed to get to them all. And I think that that's an indication of the importance of these issues and the strong level of interest that there is in them across the sector. But we will read and digest all of the questions and comments that you've posted. And lots of the detailed questions, I think, are going to be helpful as we think about how we shape the OFS's approach to this area in future. In looking at the questions as they've been coming in, one theme I've noticed is people asking whether consumer law applies to particular categories of students. So questions about postgraduate students, apprenticeships, students on level 4 courses funded by their employers, international students, and so on. Are they covered or not by consumer law? The questions they're asking. And I can see why those are interesting questions. And of course, my colleagues at the OFS always enjoy grappling with the complexity of statutory interpretation. But I wonder if that might be a bit of a red herring. I said at the beginning of the morning that we at the OFS expect institutions to treat all students as consumers for the purposes of consumer protection law, whether or not they strictly fall within the legal concept of consumer. And that's because we think all students should have reliable information when they're deciding what and where to study. They should all have fair contractual terms that they understand, and they should all be able to have their complaint properly addressed when something does go wrong. So a debate about whether or not particular types of students fall within the technical legal definitions is perhaps distracting us from that basic point. All students should have those important protections. And that's one of the key issues we'll have in mind as we develop our work on the consumer rights of students over the next year or so. So what are the norms that the OFS should set for this sector? And should our requirements go beyond those in consumer law? We've signalled that direction of travel in the insight brief that we published this morning. So I'll finish by saying, do please find time to read that insight brief and also the CMA's revised guidance, which I think is helpful and moves understanding forward on these important issues. And then finally, a reminder that we will post a recording of this event and slides on the OFS website early next week. So thank you all for coming today, and we hope you found it useful, and we very much hope to see you all next time too.